So the point of this video is to show a consistent pattern of there being a bias against fathers in family courts. Now, with that being said, this is going to be part of a series about some of the misconceptions about family court that I'm going to be putting into the corrupted file so that people can see the facts. Because I see a lot of emotion, a lot of opinions, but I want to look at the data. What does the data say? So the point of this first part of this series is going to be about child custody and the fact that fathers are often discriminated against. And people always say, oh, that's not the case, that's the case. Well, I'm going to go ahead and shut those people up once and for all. So I'm tired of hearing the lies spread around, the nonsense, the misconceptions. Let's look at the actual facts, the facts. I don't care about opinions when it comes to facts. First of all, moms are given preferential treatment when it comes to child custody. Let's go ahead and use some of the data that I found to prove that beyond a shadow of a doubt. All right, so this is from Everyday Feminism. A lot of people were shocked by this article. It was put out in 2013. So first of all, I wanted to use them as a source because it's Everyday Feminism. So whenever they are admitting to a men's rights issue, this is something that I tend to listen to because, again, it is somebody who you wouldn't think would normally say this. So let's read from this article here. It says here, one manner in which men's rights activists derail feminist arguments is alluded to instances in which women supposedly experience privilege. Often they use the court system, the custody battles in particular, as an example. So I decided to research the topic with every intention of creating a piece about how institutional sexism in the legal system affects men too. But the results of my research were surprising to say the least. It's true that mothers are more likely to receive custody of children in a divorce, but the source of the bias is not the courts; it's in the marriage. So, straight marriage struggles. The institution of straight marriage perpetuates patriarchal gender norms during marriage as well as during its complement divorce. The same unfair assumptions that undermine the tradition of straight marriage are the ones that mire their divorces. Statistically, it appears that the family courts in the United States are biased against fathers. For example, 83% of mothers receive custody of their children in divorces. Additionally, men are awarded less support on average than mothers who are awarded support. There's also plenty of anecdotal evidence citing situations where mothers were awarded custody in spite of fathers demonstrating interest and potential to provide and care for their children. There are even organizations that exist to protect fathers' rights. So, I don't agree with everything that they said here, but the numbers that they're using is absolutely valid. And let me show you the numbers that they're pulling from here, or at least some of the numbers that kind of show you that it's either 80% to 85% of mothers who get custody. So before we go any further, we again, women, I'm not attacking you. I want you to understand there's a reason why I'm going over this so that I can show you the other side of the argument so that you can have, so that maybe some women can have a little bit more empathy. It's not that I'm attacking you and say, oh, this is all your fault. Because again, most of my criticism is going to be leveled towards the courts and towards the system and not so much you. All right. So with that being said, let's move on to something else to kind of show you the custody rates. All right. So this is a 2013 survey that was issued in 2016 about custodial mothers and fathers and their child support. So the numbers that I keep pulling when I say that mothers win the vast majority of the time, it's not just the Census Bureau that says it. And as you can see there, the logo right there towards the bottom right-hand corner of your screen, you can see the logo to kind of show you that it is legit. And it's also going to be in the description. Basically, what you're seeing here, it says one out of, I'm going to highlight that part right there on the highlights. It says right here, 1 out of every 6 custodial parents were fathers, 17.5%, which means that more than 80% of the custodial parents were mothers. And those numbers have changed some, but not by a whole lot. And so I want to show you that and show you some of the reasons, some of the reasons why that happens. So we're going to use South Carolina, the place where some unfortunate things happen to some fathers. And I want to show you one of the reasons why that's happening and how some of the old school way of thoughts are still being promulgated in family courts, even to the modern day in 2020. So the site that I'm quoting right now is just the U.S. law, and this is from a 2012 South Carolina Code of Laws, Title 63, South Carolina Children's Code, Chapter 15, Child Custody and Visitation, Section 63 through 15 through 10, tender years doctrine abolished. So the tender years doctrine was not abolished until 2012. That was only 8 years ago. So let's read more here. It says the tender years doctrine, in which there is a preference for awarding a mother custody of a child of tender years, is abolished. So that was only 8 years ago. Do you honestly think that things have changed in only 8 years? When has government ever been that quick? I'm sorry, but I am a journalist from South Carolina, and I can tell you for a fact, our potholes are famous. We have potholes that are older than 10 years. All right, so as you can see here, it's only been 8 years that we've seen gender equality. So when people go out here and they say things like, well, fathers should request custody more. Well, the fathers in 2012 and before were probably doing that, right? Except the law on the books in certain states like South Carolina was that they were never given preferential. They were never given the preferential treatment that mothers were given. This is not to attack mothers. This is just to tell the truth. This is fact. This was the law. And some of the same judges that are on the bench in South Carolina were on the bench before this was actually abolished. So my question is, has things actually changed? And the answer to that is a clear and emphatic no. Because some of the numbers that I gave you just now came from years beyond 2012. And the custody rates were still pretty bad. And if the custody rate still affected South Carolina, well, things have not really changed, have they? All right, so let's move into some more evidence. One of the first things that someone's gonna say is that I'm not a lawyer, and that's true. But this guy is. His name is David Axelrod. He's one of the best attorneys in the entire state of South Carolina, and he wrote an entire article about this. Is it more difficult for fathers to get custody of their children in South Carolina? This is posted on behalf of Axelrod and Associates in 2018. So basically, I'm going to read out part of what it says. And mind you, this is a practicing attorney in South Carolina. And this is basically what he said. He says, once upon a time, mothers always got custody of the children when parents divorced. This was certainly a cultural artifact, but it also had a solid place in legal theory. According to the tender years doctrine, it is the best interest of children who cannot live with both parents to live with their mothers. This legal principle arose in Britain during the 1800s and spread to the United States and many other nations. As gender roles changed significantly during the latter half of the 20th century, the doctrine was abandoned in the United States and most of Europe. South Carolina lawmakers abolished the tender years doctrine in 2012, but the attitudes of some judges do not change as quickly as the law. And we're gonna see that one particular sentence right there. We're gonna go back to this, okay? Because before we get into child support and everything else, I'm gonna go back to that statement because there's something that he said that's very important, and there's actually a study that was done that proves what he said is true. Not only is what he said true, there is studies out there that shows that he's very right. So family court judges have a lot of discretion when deciding child custody. In South Carolina, judges consider what they think to be the best interest of the child. So a judge who buys into old-fashioned ideas, and South Carolina certainly has a few of those, might be influenced by the ideas behind the tender years doctrine, even if the legal principle has been officially abolished. For fathers involved in a child custody dispute, this means the deck is often stacked against you. That again, and he goes into some other things here, but again, I want you guys to see that. Now, what did he mean by this one sentence right here? All right, but some attitudes of judges, and he's not just talking about South Carolina. What does he mean by some attitudes of judges do not change as quickly as the law? There's actually a study that was done, and I want people to see this study, and it's going to be interesting because I want to see how people attend to, or how some people may attempt to circumvent that point when the study was done. And it was also partially done with the commissioning and the blessing of the U.S. Bar Association, the American Bar. All right, so this is a study, and it's also some research that was done by a woman by the name of Professor Andrea Miller, who is a psychology professor. And she found that judges' rulings are sometimes influenced by their own ideas about proper male and female gender roles. So the title of this study is "Judges as Susceptible to Gender Bias as Lay People, and Sometimes More So." This is from 2018, only 2 years ago. So this is actually affecting psychology, sociology, and also law. And so I'm going to read from this piece here. A new study of trial court judges suggests that arbiters of the law sometimes let their personal ideas about gender roles influence their decision making. The findings, which are part of a broader study of judicial behavior, revealed that the judges were just as likely as lay people to discriminate in ways that harm both men and women in decisions involving child custody or workplace discrimination cases related to family caregiving duties. Judges with more expertise in family law tended to engage in more biased decision-making than those with less experience in family court, said the University of Illinois psychology professor Andrea Miller, who conducted the research. She said, judges tend to believe that their vast amount of legal training and logical thinking skills make them immune to these mistakes. This research is showing that judges are not as immune as maybe they think they are. The study was conducted at the request of a group representing trial court judges. The judges wanted to know whether their own decision-making was affected by biases that could contribute to social disparities in the legal system. Andrea Miller said that they were being very forward-thinking and brave, I think, who took on the challenge while working as a postdoctoral researcher at the American Bar Foundation and is continuing the work at Illinois. The overall sample involved 619 sitting trial court judges and 504 lay people. All the judges were asked about their legal expertise. Only those with recent experience on specific types of cases, for example, child custody cases in family court, were asked to analyze cases in those fields. So that's a very, very good separation there. The study evaluated 372 judges' decision-making in child custody cases and 514 judges addressing a workplace discrimination case. The judges read about the cases and then made decisions about how to resolve them. For this analysis, the only thing that varied in each case was the race and gender of those involved in the disputes. We're giving them identical case facts, and we're only changing a couple of variables that should be legally irrelevant, race and gender, Miller said. After the judges made their rulings, they filled out surveys that tested their gender and racial attitudes. The gender ideologies test measured how much the judges consciously support traditional gender roles, where women are more or less confined to domestic caregiving roles and men are confined to more public career-based roles, Miller said. So the result is very, very interesting. Judges in the shared custody case were more likely than lay people to give a mother more time with a father, with a child than a father. The judges gave mothers, on average, about half a day more time with their children than they gave fathers. Lay people awarded 0.15 of a day more time to mothers. The judges' tendency to discriminate in this matter coincided with their traditional gender ideologies. The more that they supported traditional gender roles for men and women, the more parenting time they gave to the mother in the case. So I want you guys to see how many women may not understand that the exact same gender roles that allow you to win family court cases so much, the same attitude that's used for that is also used to justify discriminated against you when it comes to discrimination in the workplace. It's the exact same type of mindset, because Andrea Miller, I've read a lot of her work, and the one thing that I've noticed about her is that she implies things without directly saying it. But the data and the studies and the studies that she actually engages in, it kind of shows, basically what she's trying to say. It's that it's the exact same gender roles, because that's the title of the actual piece here. So in the shared custody case, the judges were influenced more by gender than the lay sample, Miller said. An extra half a day with a child each week amounts to nearly an extra month of time over the course of a year. In a workplace discrimination case involving family caregiving, the gender of the plaintiff also affected judges more than lay people. Overall, the judges and the lay people both saw the woman's case as having more merit than the man's, Miller said. But the more the judges supported, the judges supported traditional gender roles, the more likely they were to rule against a woman plaintiff on the merits. In other words, decisions in the woman's discrimination case were influenced by the judge's personal ideologies about the proper roles for men and women. So, once again, there appears to be a correlation that while there's some women out there who are complaining about workplace discrimination and not getting the judgments that they're seeking, what they don't realize is that when you support the family court system, apparently there appears to be a correlation. And mind you, she was working on this when she was with the American Bar, all right, for a postdoctoral. So I want you to understand, this is not just somebody just saying something. This is pretty concrete, all right. What she's saying here is that there is a gender bias that appears to be correlating from family court to even workplace discrimination cases, because some of the same attitudes exist. So understand, when women support the family court system, what they're actually supporting. All right. So with that being said, we're gonna go into some of the examples of some of the discrimination that when people bring up things like, well, just ask for more custody. Well, sometimes men do, and they still get screwed. And even when they get custody, some of the judges still actually screw them. And I'm going to use South Carolina as another example, because again, I want people to see the facts and see some of the cases that I'm talking about. So when it comes to child custody and when it comes to child support, I want some women out there to see what some of the men out there are saying when we refer to gender bias. So this is a case that I've written articles about, and it is so absurd because it shows just how bad it is in South Carolina. So this is actually a South Carolina Court of Appeals case, right? And this is Roessler v. Roessler, and the original judge that was involved in the case, her name was Rochelle Connitz. So Rochelle Connitz thought, and I'm just going to show you some parts of here. So as it's seen here, right? The facts of the case, basically, the husband and wife were married in 1994. They had one child as a result of the marriage. He began at the beginning of the marriage. Husband was employed with the United States with the United States Army. They lived at Fort Knox in Kentucky. The wife had 2 children from the previous marriage. In 1996, the husband voluntarily separated from the Army. In 2003, husband's Texas Army National Guard unit was deployed to Iraq for a year. And basically in 2004, he just got out. So basically he accepted a job at Kellogg, Brown, and Root, KBR. And so he worked in Iraq as a contractor, basically. So he basically made a lot of money. He was making $15,000 to $17,000 a month. His employment was terminated, right? Husband explained the wife's unhappiness with him working in Iraq, and child struggles with school caused him to miss a substantial amount of work. Afterwards, husband worked for a short time as an insurance salesman, but was soon hired by the Floor Corporation in Greenville, South Carolina. So basically, she became unhappy, just to kind of speed it up some, and the family returned to Texas to pack up some of their household goods. And basically, what happened shortly after was that there was some other movement. There was some other movements. She went to Pennsylvania for Thanksgiving to go visit her parents, and then shortly afterwards, there was a dispute, whereas she began hitting and slapping him. Um, basically, and mind you, she actually admitted to all this because it's actually in the facts. See right here, facts. So everything here is factual. This all happens. So the husband initiated the divorce based on the grounds of physical cruelty on January 17th, 2008. Wife was served in Greenville on January 28th, 2008. And so basically, the wife, the family court awarded wife temporary custody of child with visitation, and ordered husband to pay wife $1,700 per month in unallocated family support. Husband was also ordered to pay rent for wife on a house in Simpsonville, South Carolina, make wife's car payment, and maintain insurance for wife and child. Wow. So she is actually the aggressor here. She began hitting and punching, right? And basically, it was strange that it was very strange that he wasn't given custody. He hadn't done anything wrong, and they based his child support based on a job that he no longer had, because when he was working for, I mean, again, his freaking employment was terminated. And after that, became like a freaking insurance salesman, or, I mean, again, read some of this stuff, right? So, wife began hitting and slapping husband. Husband left the hotel and wife followed. As husband attempted to leave the parking lot in his car, wife used her car to push husband's car approximately 6 feet onto the curb to prevent him from leaving. Wife exited her vehicle and began tossing items from husband's trunk. Afterwards, husband and wife talked for approximately 30 minutes before wife began hitting husband. Husband attempted to leave a second time. However, wife jumped onto the hood of his car and forcibly removed a windshield wiper blade, which she used to strike husband several times. Therefore, husband requested the hotel's front desk staff call the police. Wife was arrested, and husband bailed wife out of jail the next morning. This man bailed her out of jail. All right. So, but here it continues. All right. Husband and wife attempted to reconcile, and family went bowling on New Year's Eve 2007. Upon returning home, husband and wife became involved in an argument in front of child. Wife attempted to hit husband's head against the wall. Husband explained wife did not attempt to physically damage his head, but was very physical and demonstrative of making a point. The argument dissipated, and although husband considered leaving wife, he remained in the home because of child. However, shortly after, another argument occurred, and husband left the home. So after that is when he initiated the divorce based on physical cruelty. You've had multiple instances, and one time where she was actually arrested. And yet, not only was she given custody, this man was ordered to pay $1,700 a month. All right. Now it gets even worse, right? Prior to the final hearing, wife moved to dismiss the action, arguing the family court lacked jurisdiction to adjudicate the divorce because she was a resident of Texas at the time she was served. After hearing evidence on the issue, the family court decided wife's motion to dismiss, finding it had personal jurisdiction and subject matter jurisdiction to adjudicate the divorce. The family court's final order granted husband a divorce on the grounds of physical cruelty, awarded wife custody of child. Let's pause there. They awarded him a divorce based on physical cruelty, and yet still gave the children to the physical person who was being physically cruel. Awarded wife custody of child, allowed husband 2 weeks visitation per year. Ordered husband to pay $4,000 per month in child support, and equitably divided the parties' marital property. No alimony was awarded. The appeal followed. Holy God. They made this man pay $4,000 a month to a woman who is known to be physically abusive. She was arrested for it. She took a windshield wiper and was beating this man with it. So when people speak about gender bias, it's hard to look at this and say that there is no bias here. Because again, the 10 years doctrine in South Carolina was not appealed to 2012. So that's why she got default custody, even though, and again, the law was that even if they were physically abusive, as in this case, as you're clearly seeing, they still got custody. So understand something. This is what a lot of men mean when we speak of gender bias. So I want you to understand, when we speak of gender bias, that's the kind of things that I'm talking about right around there. You can't just, if you're going to mention child custody and all that stuff, and again, if you're going to mention all that stuff, you're going to have to also mention the gender bias, because I think that I pretty much demonstrated it. I gave you a source from Everyday Feminism. I gave you a source from the Census Bureau. I went into an individual case, and I also gave you a source from an actual study that was done by a researcher that was associated with the American bar at the time. So, I mean, in the same gender roles, the same ideas for gender roles that some of these judges have, many of them still have, especially in South Carolina, especially like a deep South state, especially in the deep South. What you're seeing there is that some of the same attitudes actually punishing women in terms of workplace discrimination, workplace discrimination suits. So what you got to understand is that you can't mention child custody without being honest completely and mentioning that things are hopelessly stacked against men in some cases. And I've just given you examples of that. All right, you can't. And even if you say that well, a lot of men don't ask for custody. That is true. Men, we have to ask for custody. There's a lot of men out there who don't ask for custody, and there's no point you pissing and moaning about how women are getting custody so often if you're unwilling to fight for it. If you're unwilling, again, there's no point in you sitting there just mentioning that constantly if you're unwilling to fight for it. So I want you to understand that there's a reason why people are saying the things that they're saying, and that the evidence appears to show that those people have a point. Now, I hear things about child support, so I want to actually get into that into the next video. But this first part was about some of the gender bias, and I wanted to show people that gender bias does exist. And so this video is gonna be more than 30 minutes long. And I went over a lot of data, and I want people to see the data. I want people to see the actual studies. I want people to see the facts so that there's no more confusion about this, so that people can stop saying the things that they're saying. That being said, guys, horns up, peace out. And until part two. Part two is going to be about child support in of itself.